Hello, dear viewers. My name is Farid Nouri, and I'm an immigration consultant in Germany. In today's video, I'll explain for you about a compulsory residence in a city or a district during the asylum procedure, which in German it is called Residenzpflicht, about a compulsory residence in the first camp or initial reception center for the asylum seekers, which in German it is called Wohnpflicht, about the period of compulsory residence in this camp, the permission to leave the city or district for important appointments during this time, in which cases one can end this compulsory residence in this camp or in the city or district, and so on. In fact, after the arrival of the asylum seekers in Germany, they are usually placed in an initial reception center, which is known among the most of the asylum seekers as the first camp of the asylum seekers. In German, this initial reception center is called Erstaufnahmeeinrichtung. If the asylum seekers do not have minor children who are living with them together in this camp, they might be compelled to stay in this camp until 18 months. And this compulsory residence of the asylum seekers in this camp is called Wohnpflicht in German language. If these asylum seekers do not fulfill certain obligations to cooperate with German authorities, they may be obliged to live in this camp for an unlimited period of time. This can especially happen when the asylum seeker violates the obligation to cooperate without having an excuse for doing so, or if in the act of not cooperating there has not been his or her fault, but after knowing the reality, he or she still has not cooperated immediately. For example, in the case of submitting his national passport or his other documents which help the German authorities to clarify his identity, such as his visa, his residence permit, or some other documents which he has got from the other countries, such as his train ticket or ticket for airplane, and so on, which must be submitted to the Federal Office for Migration and Refugees of Germany or to the Foreigners Office, which in German it is called Ausländerbehörde. If the Federal Office for Migration and Refugees of Germany or the Foreigners Office asks the asylum seekers to provide to one of these offices the necessary information about their case, or one of these offices asks them to clarify the facts orally and or request them to do it in a written form, or certain other authorities or their responsible camp asks them to contact this camp or to go there in person, and they do not cooperate, they may be obligated by these authorities to live in this camp indefinitely. A special regulation applies to the asylum seekers from the so-called safe countries of origin. They are obliged to live in the initial reception center or in the first camp of the asylum seekers until the Federal Office for Migration and Refugees of Germany decides on their asylum application. It is worth mentioning that as long as the persons are obliged to live in the initial reception center or the first camp of the asylum seekers, they are subject to the so-called compulsory residence in the city or district they live, which in German it is called Residenzpflicht. If the asylum seekers have minor children who live with them together in this camp, they may be obliged to live there for a maximum of 6 months. This also applies to the asylum seekers from the so-called safe countries of origin, and regardless of whether the above-mentioned obligations to cooperate have been fulfilled. It is worth mentioning that, according to the law on better enforcement of the obligation to leave the country, since July 2017, the Federal States of Germany can oblige the persons whose asylum applications have been rejected as inadmissible or obviously unfounded to live in initial reception centers for up to 24 months. Now I would like to explain for you in which cases the compulsory residence in initial reception center or in the first camp of the asylum seekers can be terminated. First, for reasons of public health care. Second, for other reasons of public security and order, in particular to ensure accommodation or distribution of the asylum seekers. Third, other compelling reasons, for example, persons who have been victims of sexual violence or harassment there, or persons with certain disabilities. Fourth, if the asylum seekers are obliged to live in another city or accommodation, that is, if they are assigned to a municipality, which means that if the responsibility of their accommodation has been given to a municipality. Fifth, if they have been granted an international or other protection by the Federal Office for Migration and Refugees of Germany. Sixth, if they are entitled to a residence permit because of their marriage or the establishment of a civil partnership. And seventh, if they have got a rejection for their asylum application from the Federal Office for Migration and Refugees of Germany, and they have complained against it in the administrative court, and this court has suspended the decision of this office until the decision of the court about the rejection of their case. It is worth mentioning that, in this case, their asylum application should not have been rejected as inadmissible. From these reception centers or first camps of the asylum seekers will then be distributed to municipalities or to districts, and these municipalities and districts must provide accommodation for the assigned asylum seekers. These municipalities or districts usually provide accommodation to these asylum seekers either in a shared accommodation, which in German it is called Gemeinschaftsunterkunft, or in an apartment operated by the municipality or the district. It is worth mentioning that an accommodation in the shared accommodation or apartments operated by the federal state is also possible. This assignment to the municipalities, districts, or to the federal states is called Zuweisung in German language. And when the asylum seekers are assigned to a city, district, or to a federal state, they receive a letter of assignment, which in German it is called Zuweisungsbescheid. Before distribution, the asylum seekers can express their wish to be assigned or to be sent to a particular city or district. They can only be assigned or sent to the city or district if their spouse or partner already lives there, or if they are minor children and expect to be brought to their parents, or vice versa. And in such cases, a family reunification must be made possible. In addition, so-called hardship cases can also be taken into account. For example, if an old, sick asylum seeker wishes to be assigned to the municipality where his adult son or daughter lives. The same applies if there is a case of disability. Of course, other wishes can also be expressed, but the chances of success are very low. In addition, the chances of getting to a large city are also very low, because most of these big cities or districts have already taken the number of asylum seekers they had to. If the asylum seekers want to be sent to a specific city or district, they should contact the Office of the Social Services in their initial reception center, and they should give the best possible reasons for their request. For example, close relatives, care of old or sick relatives, the presence of the religious community in a certain place of residence, and so on. The employees then pass on their request to the administration of the State Reception Authority. The State Reception Authority then decides on the basis of the legal requirements, the importance of reasons, and the distribution system. In fact, according to the Section 56 of the Asylum Act of Germany, the so-called Compulsory Residence, or as it is said in German, Residenzpflicht, means that the residence of the asylum seekers in the city or district in which they are living is restricted, and even for short journeys, they may only leave their city or district with official permission. The compulsory residence applies on asylum seekers as long as they are obliged to live in initial reception center or in the first camp of the asylum seekers. And during this period of time, their stay is limited to the district of the foreigner's office or Ausländerbehörde in which their initial reception center is located. If they want to leave this area, they need a permission and they must apply for this permission at the Federal Office for Migration and Refugees of Germany. They can only obtain this permission if leaving their residence area is necessary for compelling reasons. This is the case, for example, when certain medical treatment is required, which is not possible in the area of their residence. They do not need a permission for appointments with authorities and courts to which they have to go in person. However, they must notify the Federal Office for Migration and Refugees and the initial reception center of these states in advance. For appointments with their lawyer, their legal guardian, with UNHCR or other refugee aid organizations, the authorities should grant permission. As a general rule, in such a case, an application must not be refused. If the asylum seekers are assigned to a municipality during the first 3 months after their arrival in Germany, their temporary residence permit, which in German it is called Aufenthaltsgestattung, or their proof of arrival, which in German means Ankunftsnachweis, will be limited to the city this municipality is responsible for. If they do not have to live in an initial reception center and have already been allowed to stay in Germany for 3 months with a temporary suspension of deportation, which in German it is called Duldung, or with a temporary residence permit or a proof of arrival, a compulsory residence can only be imposed on them if they are convicted of an offense or they violate the Narcotics Act, or in case they lose their residence permit in the near future, or if they pose a significant threat to internal security or to the life and limb of third parties in Germany. If they are obliged to live in a specific area, they will need a permission if they want to leave this area. In this case, they must apply for this permission at their respective foreigner's office or Ausländerbehörde. Thanks a lot for watching my video. If you would like to get similar important information about the immigration laws in Germany, your rights and duties in German society, the living conditions in Germany, and other such important topics, please subscribe and follow our channel. If you have any questions or remarks about today's topic, you can write it under this video and I will be more than happy to answer it for you.